Good evening. Welcome to Grace and Gavel, where truth meets compassion. My name is Buffy. I'm an 18-year-plus criminal defense attorney who's practiced criminal law for over 18 years, soon to be 19 here. And today we're going to talk about Leopold and Loeb, Clarence Darrow, and the death penalty, when justice becomes vengeance. They weren't desperate. They weren't impulsive. They weren't angry. They were bored and convinced that their intelligence placed them above everyone else. In 1924, two young men decided to commit murder. Not for money, not for revenge, but to prove they were superior. This is the story of Nathan Leopold and Richard Loeb, and why their case still forces us to confront one of the most uncomfortable questions in criminal law. Is justice about accountability, or is justice about vengeance? Who they were. Leopold and Loeb were brilliant by conventional standards. Leopold was a child prodigy, fluent in multiple languages, obsessed with ornithology, studying law at 18. Loeb was charismatic, wealthy, and intellectually gifted, the youngest graduate in University of Michigan history. They were praised constantly for their intelligence. Their character, however, went largely unexamined, and that distinction matters. The philosophy they misused. They latched onto a crude, self-serving interpretation of Nietzsche's concept of Übermensch, not as philosophy, but as permission. In their minds, laws were for ordinary people. Morality was optional, and consequences applied only to the inferior. This wasn't deep thinking. It was narcissism wrapped in intellectual language. The planning. What makes the case most chilling is not just the crime, but the planning. They didn't snap, they rehearsed. They rented a car under a false name, they created alibis, they scripted conversations. The goal was never just murder. The goal was proof that they were untouchable. The murder. Their victim was Bobby Franks, a 14-year-old boy who trusted them. That trust was their weapon. The killing itself was brutal, chaotic, and far from the clean intellectual exercise they had imagined. Reality has a way of intruding on delusion. The investigation. Despite their confidence, it wasn't brilliance that caught them. It was ordinary police work. A rare pair of prescription eyeglasses left near the body, one of only 3 in Chicago. Timeline inconsistencies, contradictions, overconfidence. Their greatest flaw wasn't lack of intelligence. It was arrogance. Clarence Darrow and the death penalty. The strategic masterstroke. Enter Clarence Darrow. Darrow understood something extremely fundamental. A judge is a judge because he can be fair and impartial, and he can maintain the law even when it's difficult. A jury, on the other hand, can be prone to maybe seeking vengeance or trying to send a message or be overly emotional about a case, especially a 14-year-old boy. So you think about that and you think about, which would you rather rest your chances on? Would you rather rest your chances on someone who's unpredictable, or would you rather have a steady fact finder and trier of fact to determine your case? Clarence Darrow chose the judge, of course, because Darrow understood something fundamental. A jury grieving a murdered child is unpredictable. A judge bound by law is not. So he made a decision that almost certainly saved their lives. He waived a jury trial, which means he chose to be tried by the judge. His first clients to be tried by the judge. Sentencing would be decided by Judge John Cavely alone. That choice was huge, and it mattered and had an impact. Darrow's argument. He didn't argue innocence. He didn't minimize the horror. He reframed responsibility itself. He argued that these were adolescents, not fully formed adults. Human behavior is shaped by biology, psychology, and environment. The state should not answer murder with murder. His closing argument wasn't really about Leopold and Loeb. It was about the danger of government claiming moral authority through killing. The sentence? The court agreed with Darrow. Instead of execution, they received life imprisonment for murder, plus 99 years for kidnapping. At the time, the public was outraged. They likely assumed that they would be put to death. History would complicate that reaction. What became of them? Richard Loeb never left prison. In 1936, he was killed by another inmate, slashed repeatedly with a razor in the shower. Violence answered with violence. Nathan Leopold lived. After 33 years, he was paroled. He became a model inmate. He lived quietly in Puerto Rico, and he never reoffended. That outcome unsettles people. It should, because it forces us to ask whether justice is only about punishment or whether it includes restraint. The law caught up partially. Today, the Constitution prohibits the death penalty for juveniles and individuals with a significant intellectual disability, mainly those who have a certain threshold below a normal IQ, as it should, because culpability is not binary. Executing people who cannot fully appreciate consequences is not justice. It's murder. It's vengeance. It's eye for eye kind of thought. Eye for an eye kind of thought. The deterrence myth, and that's exactly what it is, because the death penalty does not reduce violent crime. Decades of data show no meaningful deterrent effect. No reduction compared to life imprisonment. Higher financial costs. The issue with that is because the death penalty affords a lot of appeals. And so there's a lot more time to continue to try to get out of prison through using the appeals, because attorneys cost and attorneys have to be paid and things like that. There's also disproportionate error. I mean, how many people have we wrongfully convicted? How many people have we wrongfully executed? I mean, there are a lot of cases where they sue the state given the fact that they've been wrongfully convicted for many years. And once you kill someone, you can't bring them back, especially if you find out that they didn't commit the crime, which is why the Innocence Project exists, to try to help people get out of prison through use of DNA and other methods. Violent crime is rarely rational, as we know, and no one commits murder after calmly weighing sentencing charts, right? No, they don't. So what the death penalty actually does, if it doesn't deter, what does it serve? What's the purpose? It satisfies a collective emotional response. And I will say that my heart goes out to people who've lost their loved ones because they've been murdered by someone who murdered them. Totally understand that. Am compassionate of that. I cannot say that I completely understand. I've not experienced that, but I imagine that that would be a very hard, difficult thing to accept. It also ends the inquiry, right? Sometimes people are rehabilitated, sometimes they're not. It stops questions. Vengeance feels like justice until it isn't, because it doesn't bring back the person that you lost. And who it really affects, the death penalty does not fall evenly. It disproportionately impacts the poor, racial and ethnic minorities, people with inadequate legal representation. Justice in capital cases is often purchased because they can actually afford to pay for legal representation. I mean, you think about Robert Durst, for instance. I mean, how wealthy was he? You know, there were a lot of people who have the money to be able to throw money at lawyers, and they get high-paid lawyers, and they're able to succeed with the case. Poverty and representation. Defendants who cannot afford elite counsel face overworked public defenders. They also face limited investigation budgets because the defense attorneys are supposed to have similar resources to the state. But that is almost kind of in name or idea only, because they do have investigators working for them. They do have other experts that they can hire, versus defense attorneys are kind of trying to do what they can with what they have. So the resources are not evenly split. Some of you may have the idea that, you know, just because they're a criminal defendant means that they're guilty. Ultimately, though, they are afforded the right to be innocent until proven guilty. Additionally, it's the state's responsibility to provide the test, provide the proof that they are guilty beyond a reasonable doubt. and everyone is entitled to a fair and impartial jury to confront their accusers, their due process rights, the right against self-incrimination, all sorts of things, right? And so you do want defendants to have a fair trial and all of that, because ultimately, especially if one of your relatives is a victim, you want to make sure that the case is done correctly so that they're not coming back for appeal after appeal after appeal after appeal, because going through that would definitely be emotionally heart-wrenching and awful to experience. Definitely, I can imagine. I've not been through it, but I can say that I could imagine that. As well as, if you were experts, less mitigation, because again, if you're working with a single attorney versus a group of attorneys with the resources, or a more wealthy client, of course they're going to have the money to be able to afford that, but a lot of people cannot afford legal representation. And capital cases are won or lost before trial because it's the preparation, it's hunting down the witnesses, it's hunting down the experts. It's often a battle of experts, to be honest. And then let's talk about race and bias. Cases involving white victims are more likely to seek death. Defendants of color are more likely to receive it. Bias doesn't need malice to be lethal. It only needs discretion. The part people don't see. On paper, criminal defense attorneys are supposed to have the same resources as the prosecution. In practice, that parity is a myth. Prosecutors have legal secretaries, investigators, standing experts, institutional support, because they're, part of the prosecution. Appointed defense often has themselves, where you're the attorney, the investigator, the paralegal, the mitigation specialist, all at once. Not to mention trying to juggle a death penalty case when you have other clients, which could be many. And when you're court appointed, you do what you're appointed to do. And that's all at once. And then experts in discovery. The prosecution has ready access to the experts. Oftentimes the prosecution will share some of that stuff with you, and they're required to share some of that stuff with you. But again, that's not going to be the same as having your own experts. And then there's also kind of the idea that you need to ask the court, especially as a court-appointed attorney, hey, am I able to pay for this expert? I think that my client is not equipped to be able to understand the consequences of their actions, maybe due to mental illness, maybe due to repeated drug use or whatever it is. And so they're not really able to participate in their own defense. And so I'm kind of having to recreate the wheel here. And of course, the defense can request funding, justify strategy, and often reveal theory just to obtain basic tools. Although I would not recommend revealing theory, just because that could potentially get back to the state and would definitely put your client at an extreme disadvantage. And then there's discovery. We're also able to ask for discovery. But again, it goes through like drafting discovery, asking questions, doing depositions, looking for witnesses, things like that, which are also important. And then defense counsel must largely trust that the state has provided everything. And ultimately, it's not like we have ready-made access to all of their files. I will say that where I practice, I do work with some really good prosecutors who are respectful and who are, doing their job just like everyone else. However, I did, when I lived in another state, actually deal with someone who was trying to essentially doctor a deposition, which is clearly grounds for being disbarred, and that law firm should have been disbarred. And if they see this, yes, I'm talking about you, and you know who you are. If you don't know something exists, you can't ask for it, and that's the other part of it. But generally, there are conversations about what they have and what, sharing their files and such. Many wrongful convictions aren't exposed because of corruption, but because of exhaustion, imbalance, and silence. The moral reckoning. When you combine disparities in resources, disparities in manpower, racial and economic bias, and irreversible punishment, you do not get justice. You get confidence masquerading as fairness. A system that can kill the poor, the marginalized, the underdefended is not strong enough to wield death responsibly. Clarence Darrow understood something we are still struggling to accept. The justice system should not become what it condemns. The death penalty doesn't punish evil. It punishes vulnerability. And when the punishment is irreversible, humility isn't weakness. It's a moral requirement. And ultimately, I think the ultimate issue is the fact that there have been people who've been put to death wrongfully, and there's no getting them back. And that's a mistake that can't be undone. And ultimately, that is extremely sad. So thank you for tuning in, and I hope you have a great rest of your day, and hope you'll come back and see us again soon. Thank you. Bye-bye.